Judges Thandazwa Ndita, Robert Henny and Mark Scher, respectively, heard submissions from legal counsel for the main applicant, Professor Adam Mendelsohn, and the first respondent, the University of Cape Town Council. A number of other individuals and organizations are also part of the matter as respondents. Some applied to be friends of the court in a bid to provide information that might be deemed helpful. The South African Jewish Board of Deputies applied out of concern over the implications of the decision taken in June last year by the University Council. If fully implemented, it will, among others, result in the possible loss of donor funding amounting to hundreds of millions of rands. However, the board also alleged growing hostility on the campus.
A lot of the issues around this court case are around how Jewish academics and Jewish students are being treated on the university campus. And what's really been worrying for us is how incredibly hostile the campus has become. We've seen incidents of anti-Semitism arising. We've seen intimidation and threats to Jewish academics on the campus. And although the case is a technical case and a procedural case, we feel that it's very important that the way Jews are feeling on the university campus needs to be included in the discussion in the court today.
Advocate Edward Fagan, representing Professor Adam Mendelsohn, told the court, among others, the UCT Council failed to do thorough research on the implications and due process was not followed. Representing both the UCT Council and the university, Advocate Tembeka Ngukai-Tobe argued, among others, that no information was deliberately concealed, including the possible fallout. Reading from the record of the meeting, he submitted there was discussions around the issue.
You say it's totally irrelevant how much financial harm or financial loss the university might suffer. They knew there was going to be some sort of financial loss or concern, and it was a proper exercise of their power to say, well, nonetheless, we're going to make the statements we make, including the statement rejecting one definition of anti-Semitism and favouring another. We could do that because we don't need to go any further than to say we think the financial considerations are of no value or no weight compared to the moral imperative of making the statement. Is that what you say?
No, what they decided, and I read the line yesterday at page 182. I read the line from Speaker 13, who says that we will be condemned morally if in this case, where there is such urgency, we did not pass the resolution. And he says, I know that there will be financial consequences, but despite that, we must pass the resolution. Now, your Lordship might say, I don't think they should have done that. But your Lordship is then straying into the realm that really belongs to the Council as a policymaker.
The court also heard that the resolution still has to be implemented, and it has been referred to the University Senate to formulate rules.
The executive is required to develop the guidelines required for enforcing the resolutions. Therefore, until the guidelines are in place, no sanctions can be applied. However, as a policy framework, the ITF resolution remains a powerful moral statement signifying the position of UCT on one of the most urgent moral questions of the day.
South African Jews for a Free Palestine also applied to be a friend of the court in support of the council resolution. Senior counsel Advocate Jeffrey Budlander for the organisation told the court, among others, that the South African Jewish Board of Deputies is not the definitive representative body for all Jewish people.
But it doesn't represent South African Jews. It doesn't represent South African Jews who are members of Jewish organizations which haven't affiliated to it. It doesn't speak for them. It doesn't represent South African Jews who are not members of Jewish organizations at all, so-called unaffiliated. It doesn't represent them. It only represents the members of organizations which have affiliated to the Board of Deputies. The claim is simply false and it needs to be rebutted.
He added that the South African Jewish community is vibrant and diverse, with many varied stances that is not necessarily aligned with that of the board.
The claims that the Board of Deputies makes is it's really time for that to stop. To stand up and say we speak for all South African Jews, it simply is not true. If I can get personal, they certainly don't speak for me.
The full bench of judges urged that mediation would have been, and still is, the ideal course of action, warning the court hearing could have far-reaching implications. The matter has been postponed to Thursday. Mariska Botha, SABC News, Cape Town.